President Cyril Ramaphosa has formally halted the implementation of the National Health Insurance Act, pending a ruling by South Africa's highest court. In a major development that reshapes the immediate future of healthcare reform in the country, the presidency has confirmed that no provisions of the NHI Act will be brought into operation until the Constitutional Court of South Africa delivers judgment in ongoing constitutional challenges. What has been confirmed? In a letter dated 20 February 2026, the Office of the State Attorney, acting on behalf of the President, formally notified parties opposing the NHI Act that implementation will be paused. The letter makes it clear that the President has undertaken not to promulgate any section of the Act while legal proceedings, known as the public participation challenges, remain before the Constitutional Court. This means that although the NHI Act has been signed into law, it will not take effect at this stage. Who brought the legal challenges? The cases have been brought by several organizations and political actors, including Solidarity, the Board of Healthcare Funders of Southern Africa, the South African Private Practitioners Forum, and the Premier of the Western Cape. The challengers argue that the NHI legislation was passed without adequate public participation, a requirement entrenched in South Africa's constitution. They contend that the scale and impact of the NHI demanded broader consultation with healthcare professionals, funders, provinces, and the general public before Parliament adopted the law. Role of the Health Minister. The President's undertaking follows a separate commitment by Aaron Motsoaledi, who wrote on 19 February 2026 to confirm that he would not request the President to bring any section of the Act into force. This alignment between the Presidency and the Department of Health indicates a coordinated decision to allow the legal process to unfold fully before implementation begins. Constitutional Court developments. Earlier this month, the Constitutional Court issued directions affecting related cases brought by both the President and the Minister of Health. Those applications, referred to as the presidential assent challenges, sought to fast-track legal clarity around the Act. However, the court removed them from the roll and postponed them indefinitely. The court ruled that these matters would only be addressed after the public participation challenges have been finalized. The public participation cases are now scheduled to be heard from 5 to 7 May 2026. The court has instructed all parties to submit further pleadings and written arguments ahead of those hearings. Why the President took this step? In his letter, President Ramaphosa said the decision was taken to ensure orderly legal procedure and to prevent overlapping court processes. He also clarified an important constitutional point: the President does not act alone when legislation is brought into operation. According to the Presidency, implementation decisions depend on multiple factors, including the readiness and capacity of the responsible department, particularly for legislation as complex and far-reaching as the NHI. What the NHI seeks to achieve. The National Health Insurance System is a cornerstone of government's long-term healthcare reform agenda. Its stated aim is to establish universal health coverage, reduce inequality between public and private healthcare, and ensure that access to medical services is based on need rather than income. Supporters argue that the NHI is essential to addressing South Africa's deep healthcare disparities. Why the NHI remains controversial. Despite its goals, the NHI has faced sustained opposition from parts of the private healthcare sector, medical professionals, and civil society groups. Key concerns include how the system will be funded, whether the state has sufficient administrative capacity, governance and accountability of the NHI fund, the impact on medical schemes and private providers. These concerns have kept the legislation at the center of political and legal debate since its introduction. What happens next? The Constitutional Court's ruling later this year is expected to be decisive. If the court finds that public participation was inadequate, Parliament may be required to revisit parts of the legislative process. If the challenges fail, the government could move forward with implementation, though questions about readiness and funding within morning.